We just wanted to continue on the foreclosure, and this session, which we want to talk about, is dealing with the impact that foreclosure has on tenants, and obviously it's a substantial impact. Again, my name is George Gould. I'm with Community Legal Services in Philadelphia, and we have the pleasure of having David Rambler, who is the representative in Washington for the National Housing Law Project and is very involved in this particular issue. I think, as most of you, if not hopefully all of you, are aware, Congress passed last year the Protecting Tenants at Foreclosure Act, which was a federal law which made some major changes in the impact that foreclosure has on tenants who are residing in properties where the landlord ends up losing the property, and often the property is purchased by a bank. So what we want to talk today in a session, which I understand is abbreviated now by 5 minutes, is the new law, some issues relating to it, and how it impacts on your clients. So with that, David's going to go over the new law, its provisions, some of the recent amendments to the law, and then we're going to talk about some issues and also open it up for questions. David?
Okay. Good morning. I do work with a national organization, but I was a legal services lawyer for a number of years focusing on housing. And so
You're still a legal service lawyer.
So here I am, right? I do work for a nonprofit. I will say I apologize for some of the materials because the materials I sent in had some track changes on them. And on page 6 of your materials, which is a copy of this law, you'll see some stuff which is very hard to read because on my copy it's in red. You can go to our website, National Housing Law Project, that's nhlp.org. You'll see it on the materials, nhlp.org, and you can get this in its form where you can read it all. I don't know how much anyone knows about this, but on May 20th of 2009, the President signed a bill passed by Congress which said that in the event of a foreclosure, if the property is occupied by a tenant, the successor in interest, be that the foreclosing mortgagee or a speculator or anyone else who buys that property through the foreclosure process, may not evict the tenant without giving that tenant 90 days notice to vacate, and if the tenant has a lease, the tenant is allowed to live out the term of the lease. So if they have a 3-year lease, they get to live there for 3 years, and they must also get 90 days notice. If they are on a tenancy at will, or a 30-day tenancy, or any other kind of tenancy, the minimum they get is 90 days notice. That's basically Section 702 of the law. Now, the part that's very hard for you to read, which appears about halfway down page 6, was part of an amendment which occurred this last summer because there was some language inserted in the bill which arose out of someone's experience in a particular state and therefore was misinterpreted across the country. And the language, which is sort of fuzzy on yours, says that where the statute uses the word foreclosure or date of notice of foreclosure, the notice of foreclosure shall be deemed to be the date on which complete title to the property is transferred to a successor entity or person as a result of an order of a court or pursuant to provisions in a mortgage, deed of trust, or security deed. The reason that language is important is because whatever your state law is, there is a point at which the state law would say title has transferred. So notice of foreclosure doesn't mean when the bank sends a 30-day delinquency notice to the defaulting mortgagor. It means when, through the process, someone else other than the mortgagor acquires the mortgagor's title, the successor in interest. So with that caveat, we're going to talk a little bit about the implications of this law. There's an outline on page 5 of your materials, and you'll see at the top there's some studies done by some national organizations, the National Low-Income Housing Coalition, which indicated that across the country, about 40% of all residential properties suffering foreclosure were occupied by tenants. Now, you can understand that that would be pushed up in a city like Philadelphia or New York, where there are large multifamily apartment complexes which are going into foreclosure. But across the country, there are many, many single-family homes, and single-family in federal parlance under RESPA means 1 to 4 units, that were also going into foreclosure. This law covers every single residential property in the country. So that's a lot of people, 40%. And you also know, I think, that there are a lot of mortgages where the bank thinks it's an owner-occupied mortgage because you get a % drop in your interest rate if you say it's owner-occupied, but are actually tenant-occupied. So the statute governs successors in interest. And as I've said, there are really 2 different categories, one where the occupant has a long-term lease and one where the occupant has a shorter-term lease, but in any case, 90 days notice to vacate is required. And I suggest that the question is, what's notice? I think it has to be whatever notice fits Pennsylvania law or your local jurisdiction. So there's no uniform type of notice across the country, but it's whatever kind of notice is required by your local law. The exception to covers everybody is that it only covers bona fide tenants. So the statute has in it a definition of bona fide tenant. The tenant cannot be the mortgagor or the mortgagor's child, spouse, or parent. So this law is adopted on May 20th of 2009. And on May 21, I get a call. I rent from my brother. Well, those of you, I don't know whether you're counselors or lawyers, but those of you who are law trained, remember this is axiom that you may have learned in law school, which says expressio unius est exclusio alterius, which means if you express one thing, you exclude the alternatives. So, brother is not an excluded category. And it raises a question that across the country, banks who hate this law for the most part, avoid it, ignore it, and disobey it in massive, to a massive degree, are always looking for some excuse to say that the tenant's not a bona fide tenant. So the other requirements for bona fide tenant are that the rent being paid is not substantially below market unless that reduction is due to a subsidy. So a Section 8 voucher holder can be paying $5 a month, their rent share, and still be paying fair market value or not substantially below fair market value within this context of bona fide tenant. But you can certainly appreciate that a bank would say that anything below top dollar is substantially below, and therefore this family is not a bona fide tenant. The final requirement for bona fide tenant is that the lease is not an arm's length transaction, which brings us back to the first issue. Excuse me, I've developed some allergy, so I apologize. What is an arm's length transaction? It's whatever 2 strangers might agree is a fair deal. But just because you're the brother or the mortgagor doesn't mean it's not a fair deal. And we have seen cases where banks come in and they argue it's not a bona fide lease because there's too close a relationship. They're old school friends or, their mothers or whatever. So back to the Latin phrase. Congress determined what was too close a relationship. So a bank cannot be allowed to come into court and say, this relationship is too close. Congress identified 3 relationships which were too close. They knew they could identify others, they didn't. So unless the relationship between those parties is spouse, parent, or child, it's a bona fide tenancy. Now, that's basically Section 203 of the Act. I'm sorry, 702 of the Act. 702. 703 specifically addresses participants in the Section 8 voucher program. Participants in the Section 8 voucher program have all of the protections of every other tenant, but they have additional protections. In addition to the fact that the successor in interest becomes the landlord under the lease, they take pursuant, the phrase is pursuant to the lease. They also must accept the Housing Assistance Payments Contract, commonly called a HAP contract, HAP, which the owner of the property has with the managing agency, the housing authority, or some other agency which is managing the Section 8 voucher. They are subject to the existing lease, which is governed by federal law. All Section 8 voucher holders have leases which must have provisions governed by 42 U.S.C. 1437 F07. And there is no bona fide tenant requirement under Section 703. If you're a Section 8 voucher holder, you are deemed under the law to be a bona fide tenant and to have a bona fide lease. Now, the successor, whoever it is, takes subject to the lease. So, if under the lease existing with the defaulted mortgagor, it is the landlord's obligation to pay utilities, it now becomes the bank or the investors or whoever the successor is, it becomes their obligation to pay the utilities. It becomes their obligation to fix the toilet. It becomes their obligation to do whatever the landlord's obligation is under the lease, and it's the tenant's obligation to fulfill the tenant's obligations under the lease. So, we're going to talk about this a little bit more in the context of Pennsylvania law. But normally, under this law, the tenant is obliged to pay rent to the successor in interest. Banks don't want to be landlords, and they're probably not licensed landlords in most jurisdictions in any event. Now, if I own a property that I rent out to tenants, I have to be registered or have a registered agent in Philadelphia, for instance. And because banks don't want to do that, they really don't want to set up this landlord-tenant relationship. And I'd be very curious, because there's a program starting at 11:15 with John Abel and David Blecken, who are from the Pennsylvania Office of the Attorney General and the Pennsylvania Department of Banking, to see how they view this issue. Across the country, banks violate this law all the time. There are continuing stories from 2 days after the law was passed until just last week in NBCnews.com, Atlanta, Georgia, of banks authorizing their agents to drive people onto the street without recognition of this law, in violation of local landlord-tenant law, putting all their worldly possessions on the curb. They're just heartrending, and they're illegal. And it doesn't matter whether the entity which obtains that order that takes the sheriff out there is a servicer, a lender, a speculator. It doesn't matter. It's in violation of the law. Now, there are a couple of tangential issues. Security deposit. What happens to the security deposit? We don't have any litigation really on the question, and once again, it's a state law question. It may be that the tenant must go back to the original mortgagor, their original landlord, for that security deposit. It depends on state law, and George will talk about that somewhat. The matter of repairs, we'll deal with a little bit. There's this issue of right of redemption. When a property goes to foreclosure, the mortgagor has a certain period of time in which, if he or she pays off the debt to the foreclosing lender, they get the title back. No? Peter says no. Not in Pennsylvania? There's no right of redemption. Okay.
For taxes.
We'll move on.
Right for taxes, not for foreclosure.
For taxes, okay. All right. You'll see on pages 7 and 8 things which have a little designation that they're a footnote. And it's because I wrote a longer article for a publication, but these are all the footnotes. They are research materials which support this law, which talk about the implications of the law across the country, which cites you to resources. So I'm not going to go into it. We really don't have time. But there are a lot of links here which I think have a tremendous amount of information. There's one more little wrinkle which we've been dealing with the feds about for about 10 months now, which has made it crystal clear, as if we didn't know, that FHA thinks that their clients are the lenders, not the people who live in these homes. If FHA insures a mortgage, they have what's called an occupied conveyance policy. When the mortgagor defaults and the lender wants FHA to pay off on the insurance, HUD says, you must deliver us an unoccupied property, a vacant property, and it is a lender's obligation to make sure that that property is vacant before we, FHA, pay off on our insurance obligation. Now, that of course encourages lenders to drive people out of their homes. And in this case, if the occupant happens to be a tenant, it encourages them to violate the Protecting Tenants of Foreclosure Act. There's a long history, 20 years, I guess the litigation was in the 70s sometime, after which FHA was required to send a form letter. FHA required that their insured lenders send a form letter to the occupants, and it says, dear occupant, in the next 60 to 90 days, we expect this property to undergo foreclosure, at which time we intend to convey title to HUD, and HUD requires that the property be empty. If you wish to remain in the property, you must apply to HUD. And in their benevolence, if you meet strict criteria over which they have total control, you might be allowed for a little bit of time to stay in the property. If, for instance, you are suffering from a serious illness and you would die if you had to move. You'll see on page 9, there's the links to 2 different HUD handbooks, which have as Exhibit 1 and Appendix 1 and Appendix 40 to those particular handbooks, the same letter and the same requirement that it be sent to the occupants. Now, this letter does not say, this is one of your options. It doesn't say, oh, by the way, maybe you want to look up something about the Protecting Tenants of Foreclosure Act. It says, if you don't do this, you're toast. So we've been fighting with FHA in Washington, had several meetings with them, and they just, as a federal judge once described a state bureaucracy, Health and Human Services, to me, it's like a big marshmallow rolling down the road, you know, and you're in the road. It really doesn't care. And this is going to affect a small number of people because, for the most part, FHA insured loans are owner-occupied. But there is a population out there that fits within this category, and so you ought to be aware of it. And this is treated on nhlp.org along with this other material, and you can go and see our write-ups on it and our discussions of this issue. With due credit, I should also say that the National Low Income Housing Coalition and the National Law Center on Homelessness and Poverty, which are also cited in here, have done a tremendous amount of work on this issue. George?
Yeah.
Hold on, I gotta look at my cell phone. I'm watching.
Let me briefly talk about how
15 minutes. We've got 15 minutes.
how this law impacts specifically on Pennsylvania. You know, when this law was written, it's very short, it's 1 page, and of course it applies to all the states which have varying eviction procedures. Some are very quick, some are longer, but you know, the law does not at all control the state eviction process. So the question is, how does this apply and what's the implications in Pennsylvania for tenants? And I would say in our office in Philadelphia, about 5 to 10% of the tenants who come in are tenants who are being evicted because their landlord has been foreclosed. Prior to the law being passed in Pennsylvania, if and hopefully people are aware of this, if you were a tenant and your landlord lost the property, generally your lease was extinguished unless your lease was entered into prior to the recording or the entry of the mortgage, which was foreclosed. If it was, then whoever purchased it would take it subject to the lease. But in most instances, the lease is entered into afterwards. If the property was sold at a sheriff's sale in Pennsylvania, the purchaser would be required, even though the tenant is no longer a tenant, but they would have to go to court and file basically an ejectment action to get that tenant out. And that process could take between basically 2 to 3 months. So this law changed it, and it said that despite what Pennsylvania law was, the purchaser of the property at sheriff's sale takes the property subject to the lease. Now, for many of our clients and for many of your clients, they're on month-to-month leases. So that effectively, their lease is going to end soon after the purchaser acquires the property and, giving the 90-day notice. The question we have when people come into the office, and it's something you want to consider, do you want that tenant to become a tenant of the bank? Is it in that interest to do that? Now, clearly, if they have a lease, and in some cases we have tenants we had a 2-year lease, in fact, we had a 3-year lease. And obviously that tenant has a tremendous interest in remaining in the property, and we ended up fighting a case in court where the bank came in and tried to file an ejectment action. In Pennsylvania, our experience is that banks do not follow this process. They sometimes give the notice, they don't go to landlord-tenant court, they continue to file the complaint and ejectment. So the question becomes for the tenant, and this is something we explain, do you want to get involved as a tenant of the new landlord? That means you have to begin paying rent. That means if you don't pay rent, you run the risk of them going to landlord-tenant court, getting a judgment against you for money, and also affecting your credit. If you don't do anything, most likely what will happen is that the landlord will file a complaint and ejectment, not naming you. Most 90% of the cases it just says occupant, and effectively that tenant will have probably 90 days. They will also have the ability probably to negotiate a cash for keys, which is the old slogan that the purchasers or banks use. We will give you cash if you give us the keys, possibly for $1,000, possibly for $1,500, depending upon how quickly one gets out. So it's worth having a conversation with the former tenant or the occupant as to whether or not they want to get into a new relationship and force that relationship on the owner. If they have a lease that is clearly going to run, for a period of time, it's obviously in their interest to do that. But as most tenants, often these properties are in pretty poor condition, although clearly the purchaser at the sheriff's sale is required to maintain the properties and required to provide utilities. But often the tenant at that point is probably not all that keen in remaining in the property. Some are insistent that we want to remain, and if they do that, you should make sure that they are able to exercise their rights, contact the attorney, inform them of the law, and make sure that they enter, that lease is continued, whatever it is. But you have to remind the tenant that means they have to begin paying rent. For many tenants, when there's been a sheriff's sale, they've stopped paying rent. They found out that there's been a foreclosure going on, and probably for a period of 3, 4, 5 months, they probably haven't paid rent, and probably, in many instances, probably even haven't escrowed the rent. So one of the questions is, do you want to become a tenant of this new landlord? I mean, obviously, there's a plus side there because, the landlord clearly has to, the purchaser clearly has to maintain that property and make sure the property is in good condition. The purchaser also in Philadelphia, and I think some other jurisdictions in Pennsylvania, they have a licensing ordinance. In Philadelphia, it's called the Housing Inspection License, where you have to go out and get a license. If you don't do this, there's no obligation on the tenant to pay rent. So that's an argument you can make. Problem is that landlord, despite that, can go to court, and in Philadelphia Municipal Court, a lot of judges just totally ignore that. So you have to have this discussion with the tenant. One of the questions came up is the security deposit. In Pennsylvania, generally, if a property is sold, the new landlord assumes the obligations and responsibilities of the old landlord, and in theory would be responsible, would have to get that security deposit if they purchase the property. Question, in a foreclosure situation, is the new purchaser responsible for that security deposit? It's conceivable you can make the argument, but the purchaser could also argue, yes, I may be responsible for the security deposit, but you're obligated to me for any past rent that was due prior to the sheriff's sale. So I'm not sure it's advisable, and I would suspect in many instances that we have found it's pretty substantial because tenants find out that properties are in foreclosure. Generally, the bank will simply mail a letter to the property. They often do not know it's a tenant property. They just mail the letter, and the tenant may open the letter and all of a sudden finds out there's a complaint in mortgage foreclosure, or the complaint gets served. And once that happens, a lot of tenants simply stop paying rent. So I'm not sure it's a good advice to give the tenants to go after the purchaser to try to get the security deposit, because I think if a judge buys that, I think they're also going to possibly buy the argument that the tenant is obligated to pay any past rent. So in Pennsylvania, and again, I think you have to advise the client on a case-by-case basis what's in their best interest, and obviously it depends upon what the tenant wants to do. We've had tenants on a month-to-month lease who still insist, I want to stay in the property, I want to have the landlord maintain the property, I want to exercise my rights. And if that's what the tenants want to do, then obviously they have the right to do it. There are some other issues that come up here. You know, one of the issues is, when does the purchaser have to give the notice, the 90-day notice that they have to leave the property? We've had cases come in where, and the purchaser is going to common pleas court and filing an ejectment action. But what they do is the day they file the ejectment action, they also send the 90-day notice to the tenant saying you have to leave. And we file preliminary objections in those cases arguing, no, you can't do that. You cannot file at the same time. Now, what they're arguing is that, you know, they hope that the 90-day period will coincide with how long it takes them to actually go to common pleas court and evict a tenant. Now, case law in Pennsylvania is a little bit unclear. There are some cases that say, you know, a straight landlord-tenant case, on a notice to vacate, you can go to landlord-tenant court at the same time you actually give the notice. We believe that is improper, but there is one superior court case which implies that you can actually do that. But you know what we do, because most of the cases that come in, tenants come in with a complaint and ejectment, and also the notice to vacate, and the time periods are running, and we just file preliminary objections. Generally, those cases get settled with some kind of favorable settlement to the tenants, where they don't have to pay rent for a certain period of time, and they'll actually get a cash for keys settlement. As I said, you know, the law and its impact varies throughout the country. In Pennsylvania, we're somewhat fortunate to have a relatively long period of time for tenants after sheriff's sale to be able to remain in the property. Now, that's not to say that some purchasers ignore the courts, as David said, simply come in and dispossess those tenants by just bringing a truck up or sending a letter to the tenant saying you have to be out immediately. We see less and less of those cases. Most of the big foreclosure firms know, and I think Mike McKeever is coming here. Folks can ask him about that. But most of the firms know that you can simply not, after a sheriff's sale, go in and kick the occupant out. That whether it's the former homeowner or whether it's a tenant, you have to file a complaint and ejectment. But sometimes we'll get a purchaser at a foreclosure sale who is not a bank, that maybe not even have a lawyer, and just take their own means to get people out, which does not involve going to court. Questions?
A situation in which a tenant has a year's lease. The year will run out less than 90 days after the successor interest takes title. The lease requires a notice to vacate or to end the lease, or it'll flip over for another year. This notice has to be sent sooner than 90 days. It has to expire sooner than 90 days after the successor takes interest. Does this person who might want to stay have another year's lease? Does the lease renew itself because they're the successor to the lease?
The theory is that the notice has to be sent 120 days before the end of the lease, and the successor acquires it 80 days before the end of the lease.
Something like that, yeah.
I think they're obliged to abide by the lease.
Yeah,
I think they got a tenant.
Yeah, I think so too.
The question that I had is, in some cases, we run into, especially now going into the winter months, where we've had numerous people coming into our office that are still looking and paying their rent to their landlord, but the utilities were in the landlord's name. And the landlord is very well, knowing that the home is going into foreclosure, is still accepting the rent and has stopped paying the utility bills. And at this point, the utilities have gotten so high that there's no way for the current tenants to take the utilities into their names, and are trying to work out with the local sheriff's office or whomever to stay in the property for that additional time, but they can't afford to, because how do you require that the landlord pay the utilities in that case?
Well, in Pennsylvania, and I hope folks are, if this is prior to the sheriff's sale, Pennsylvania has a law, which is, there's two laws, effectively they're both called USTRA, which says that if a landlord does not pay your utility bills before the utility can shut off service to the tenant, they must send a notice to the tenant. And this applies to publicly owned and utilities regulated by the PUC. They must send a notice to the tenant informing the tenant that they have the right going forward to begin paying utility bills. And they have 30 days to do that. And if a utility does not do that, you could either go to the PUC or actually you can go to the Attorney General's office. But the utility cannot shut off a utility in Pennsylvania because a landlord has not paid the bill without sending that letter and giving the tenants 30 days to begin. What they have to do is pay the bill for the last 30 days. Now, in a multifamily property, that becomes a little bit more complicated because the bill has to be paid and the tenants have to get organized, but they have to pay the last 30 days. But in a single-family property, the tenant has a right to pay that bill, and the law specifically says they also have a right to deduct that from their rent. Now, utility companies do not always follow that, but that applies to all utility companies in Pennsylvania.
The other thing you raised is negotiating with the sheriff. The sheriff is an officer of the court. The sheriff is going to do whatever the court ordered. What the tenant needs to do is take a copy of this law, and on our website we have sample letters to judges and sample letters to banks and sample letters to landlords. Take a copy of the sample letter to judge, attach it to whatever your local jurisdiction allows the tenant to do, file a petition to stay, get it in front of a judge, and in the best of all worlds, a judge would acknowledge that the federal law supersedes whatever the successor in interest thinks they're doing. Or in this case, that whatever the sheriff intended to do, that needs to be stayed by a court order. Sheriffs are not independent actors, although they don't always understand that. Anyway, okay, that's the only caveat I have.
One of the things that's important to do is to educate local judges about this new law, and also educate attorneys for lenders about this new law. In Philadelphia, we have tried to do that, I think, with some success. But they don't assume that they know what this new law is. In fact, I would assume the opposite, that they have no idea what the new law is.
Right.
So it's very important through some mechanism, through your local bar association, if there are judges' meetings, that you inform judges about it. And also, I don't know what kind of association they have of lenders' lawyers, but make sure that they're aware. I suspect that most lenders who are working for the big banks are well aware of this law. They hate it, but they're well aware of it.
And they routinely ignore it.
Any other questions?
Hi, I just have a quick question. Where does a lease to purchase individual fall within this new law? Is there any protection for them?
Well, they have a lease, right? It's a contract. I don't, we try and keep track nationally of the cases that are litigated around the country around this law, and we don't have a decision. There may have been some local things that didn't show up, you know, on the national, on Westlaw or anything, but I'm not aware of any appellate case which decided that. I would argue that that's the contract, and the lease has within it, just like it has a provision on who pays the utilities, and it has a provision on when it expires, it has a provision that if the tenant behaves in a certain way, they will work themselves into a position to purchase.
Yeah.
And I would say that's enforceable.
Yeah, I think this is one of the things that at least the lawyers in the room are able to argue both ways. I mean, one of the things we have done over the years is to argue if someone has an installment sales contract or a lease purchase, effectively they own the property and they should have the rights of all other owners, including the right, to HEMAP, in Philadelphia, the right to participate in the diversion program. On the other hand, I think one could probably effectively argue that if the owner is not going that route, is not going the route of being an owner, that in fact they are tenants, and maybe depending on what the installment sales contract is, that over a period of time, at some point they can, buy the property. At the time there is the foreclosure and the landlord loses the property, at that time they're still a tenant and therefore the law protects them.
One of the things you see in these situations is that a lot of times the tenant with the lease purchase agreement has agreed and has over years put in lots of money to renovate or to keep the place up, because the landlord doesn't want the responsibility, and that's why they enter into these things. So I would say that's an equitable argument in a common pleas court or even a landlord-tenant court in your favor, that the tenant has performed above and beyond the payment of rent and has therefore effectively earned the right through their executory performance to the benefits of this lease purchase lease.
Okay. I think that's it.
Okay. Thank you.
So I just want to mention to folks, we're 5 minutes ahead because we've reserved some time for Brian Hudson when he gets here. He was not able to make remarks this morning. So we're taking a break now. We're coming back at 10 after, and we have a panel ready to go at that time.